welcome to Rightly Decided, the most originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorneys Nathan Seltzer and Clayton Calvin, as well as our Director of Litigation, Chance Weldon. We're here to bring you the Supreme Court cases as they drop this session. And on today's docket, we have two cases about defendants' rights. One very old, so ancient, in fact, that we almost didn't bother putting it in our Constitution, and one so new that we didn't even recognize it until 1987. We might not get to that second case, depending on how the first one goes, because as we're about to discuss, this first case is actually really, really important. You're going to have to bear with us a little bit, though, because it's heavy on Calder v. Bull, which is a really old probate case dealing with dead people from hundreds of years ago, and it's going to be boring for a minute, but I promise it gets better. It's important. It's really, really important.
Who are we kidding? We know that this is why you guys are listening to us in the first place. So.
I hope so. Mm-hmm. I really hope so, because it's going to be rough for a minute. But we'll get through it.
It's not going to be rough at all.
But the case itself actually is pretty short. This is Ellingberg v. United States. Basically, Mr. Ellingberg was convicted in 1996 of an aggravated robbery that he committed before that point in time, obviously. And after he was imprisoned and tried for this case, but before he was sentenced, the federal government passed the Mandatory Victims Restitution Act, which required that he be, as part of his sentence, forced to pay upwards of, I think at the time it was something like almost $8,000, which would be like $15,000 in today's money, into the Victims Restitution Fund. And Mr. Ellingberg got out of prison and was out on parole, and he actually filed against his parole officer, filed a pro se document basically saying, I shouldn't have to pay this because it's ex post facto. Mm-hmm. So, Nathan, what is ex post facto, and why does it matter in this case?
I would think we want to start with like why this case is important, and ex post facto is why this case is important. Mm-hmm. And just for the record, the case that we're talking about today is not old. The right is old, and when we get to a later case, then that's pretty old. But this case is really important because of why originalism is important. It's for the same reason. The case implicates natural law and how the law operates, and so. We're doing originalism here because when we're trying to understand what an instrument means, we have to look at the text. But we interpret like an older text based on, not on the modern evolution of language, but based on what the language meant at the time that it was used. And this is inherently obvious. We know this when we're interacting in our daily lives. If your grandma says to you, "Don't get fresh with me," that means something. It doesn't mean don't put on deodorant with me, which is what it might mean in today's terms. It means something to her. And so you take what she meant when she said it, not what you might infer from what she meant when she said it. And so what an ex post facto clause is it's a punishment or a change in the status of an act. So like when you committed an act, it might not have been a crime. For example, driving on the freeway at 70 miles an hour might not have been a crime. But if they retroactively lower the speed limit and they say the speed limit's now 50 miles an hour on the freeway, not 70, and since you drove 70 yesterday, you actually violated the speed limit, then that would be an ex post facto clause because they've changed after you did the act of driving 70 miles an hour on the freeway. It was legal when you did it. Now it's not legal. And we're saying that the court is saying that is a violation of the Constitution because it's changing the status of an act, a perfectly legal act that was totally legitimate when you did it, and they made it illegal.
A retroactively applicable law.
Right. Yeah. So that doesn't mean that, by the way, if they lower the speed limit, don't go and drive. If they lower the speed limit, don't go drive the old speed limit because the new speed limit is prospectively applies, obviously.
Yeah.
So this is an interesting case in a variety of ways, particularly because it comes up on a pro se defendant's motion, which is extremely unusual for a pro se defendant to get to the Supreme Court, but also because the government didn't actually defend the Eighth Circuit's decision holding that this wasn't ex post facto. So, Chance, what happens when the government says, absolutely not, we're not going to step in and defend our position in this?
So when it happens on appeal, the Supreme Court can appoint an amicus counsel, right? This is someone who is, not, a party to the case. They pick a good lawyer to come and argue and defend the lower court's ruling. That's whenever on appeal to the Supreme Court and cert's been granted and the government decides not to defend what the lower court did in their favor. Now, there's a dispute as to whether or not the executive branch should do this or shouldn't do this. I'm of the mind, I think the founders were of the mind, that everyone swears an oath to defend the Constitution, and if the executive believes something is unconstitutional, then they shouldn't defend it. Thomas Jefferson famously refused to defend the Alien Sedition Act. President Reagan refused to defend parts of the Banking Act. President Trump originally refused to defend parts of the Affordable Care Act whenever that went to the Supreme Court. So there's a long tradition of the executive taking his oath to the Constitution seriously and not defending it. But then the question becomes, what do you do at the Supreme Court once, they've already decided to take the case and there's no one there to defend the decision of a lower court? And what the court does is appoint amicus counsel.
So amicus counsel comes in on behalf of the government and argues the government's position, basically.
Well, defends the lower court's ruling.
Well, defends the lower court's ruling.
Yeah.
And that's exactly what happened in this case, right? That's the amicus came in and argued, essentially, this is the only argument they could make. This is not a criminal law. The Victims Restitution Act is a restitution act. This is civil. Ex post facto doesn't apply to it. Clayton, what did the majority hold in this case?
So the majority's opinion is actually very simple and very short. It's just a 5-page opinion. It's the concurrence that's really the interesting. That's about 20 pages. But the majority here just held. They assumed that the ex post facto clause only applies to prohibit retroactive criminal laws instead of civil laws.
And we'll circle back on that assumption in a minute here.
Yeah. So they just assumed that. They didn't. Interestingly, they didn't really go into why that's the case. They sort of just they just assumed that it was. And so the whole opinion really is just an analysis of the statute itself. It's a statutory analysis case, and they're deciding, is this a criminal law or a civil law?
Which statute are you talking about?
The MVRA, the Mandatory Victims Restitution Act. It was the one that was passed in the interim before this particular defendant's sentencing hearing. And so, so they were deciding whether this statute was criminal or civil. And even though it's civil, they said restitution seems to be a civil penalty. Most of the time, there were a variety of factors that weighed in favor of this being a criminal statute. For one, it's in the criminal code. It says this is a criminal statute, basically, on top of it.
It helps when they label things.
This is a criminal law. But to be fair, that also shouldn't, be outcome determinative for the court's purposes.
Why do you say that? Why do you say it shouldn't be outcome determinative?
Well, the concurrence gets into that a lot, but basically because courts are Article 3. It's an independent branch of government. They should be applying their own independent judgment. And they're there to protect defendants' rights and individuals, and so they can't just allow the government to play, a semantics labeling game to get around the constitutional right.
This comes up a lot in the Commerce Clause context, right?
Yeah.
The fact that the federal government or Congress has said, "Oh, this is a regulation of interstate commerce."
Yeah.
The Supreme Court in cases like Morrison has said, "Well, we're still going to look at what it actually substantively regulates. We're not going to just take your word for it. If it looks like a duck and walks like a duck and quacks like a duck, it's not an ostrich, right?
Yeah.
We're going to look at it and see what it really is."
The legislature doesn't just get to say, this is not an unconstitutional law.
And the concurrence gets into a lot of this, but a law has a certain function, and that function is what we care about. What does it actually do? If the legislature just lies about what it does, or strips away due process protections or something like that, that doesn't convert it into a civil law. We're going to look at actually what happens with the law.
If judges just defer to that, it defeats the point of having judges. But yes.
But here,
the fact that this is a criminal law, that was just one factor. But how it operates, how it was enforced, were the predominant factors. So even at the sentencing hearing here, the government is the party who is adverse to the defendant, not the victim. So it's not just two victims.
So for people who didn't go to law school, if I am the government and I am bringing a case against someone, a criminal case against someone, is that the victim's case against that person? Or is that's the government against that person?
Right. Yeah, no, that's an important distinction. So if you'll notice, the only entity that has the authority to prosecute crimes is the government. Even though, obviously those crimes have victims and there might be civil penalties to restore the victim. But
that's demonstrated here because when the government wouldn't defend the case, they didn't bring in the victim,
right.
even though the victim was the one that's getting the restitution.
Yeah.
So they have brought in amicus. So.
Right. Yeah. So government is the adverse party at the sentencing hearing. And the sentencing not guidelines but provisions in this act are only applicable to criminal defendants, notably. And so the holding specifically was if Congress intended to at least impose a punishment that ends the inquiry. Also, if it's both criminal and civil, then we're gonna construe this to be a criminal law, and therefore the ex post facto clause applies. So that's the short majority's opinion.
So just to say it in a sentence, this is a criminal law, therefore the ex post facto clause applies, and therefore this is an illegal sentence.
Yes,
That's
and we
it.
know that because of the statute.
And it took 5 pages to say that.
Yep.
And then we get to 20 pages of Justice Thomas and Justice Gorsuch talking.
As is often the case, the concurrence from Gorsuch and Thomas is longer and more interesting. Right?
Yeah, totally. And the interesting part about it also is that when you look, it's much ado about this criminal versus civil distinction. But if you look at the actual ex post facto clause, there are two actually. There's one against the feds and one against states.
Two where? Two in statute? Two in
these are
the
constitutional
Constitution.
provisions.
Okay.
Yes, the ex post facto clause. Correct. Thank you. And like one here says, so I'll read Article 1, Section 9, Clause 3, important citation for our listeners. No bill of attainder or ex post facto law shall be passed. That's what it says. And the other provision mirrors that. So I'm
absolutely nothing about criminal, civil.
No, this distinction between criminal laws and civil laws, not in the text. So as originalists, that begs the question, why should we care?
Sounds
Where
like it
do
might be
we
worth a
go?
20-page concurrence.
Yeah, sounds like some explanation is necessary.
The best part is that Justice Kavanaugh is applying like a 6-factor test or 7-factor test to this, but his
very
opinion
squishy.
is only 4 pages.
Yeah.
And then Justice
Right.
Thomas is like, this is way easier than this. Let me, for
explain
20
why.
pages, explain why.
Okay, but
Ironically, yeah.
in fairness to Justice Thomas, there is a case underlying his opinion that is very, very old and extremely complicated. Nathan, will you? Oh, sorry,
I
Chance.
think like before we even do that, like what is it that Justice Thomas's concurrence is about? Before we nerd out on Calder versus Bull, and I do,
we gotta go right there.
I do want to nerd out on Calder versus Bull. Maybe we should say exactly,
Please stay tuned.
Why Justice Thomas thought he needed to write, joined by Justice Gorsuch, and what he held in his concurrence. Anybody wants to talk about that?
I can.
Yeah.
So Justice Thomas, I don't know why he decided to write, but he wanted to draw attention to these natural law underpinnings that are behind our Constitution, and he wanted to kind of point that out. Basically, the thrust of this concurrence is, well, he says kind of sideways that Calder versus Bull might have been wrongly decided, and that this should apply both to civil and criminal laws.
He sort of out originalists the original
Yes.
originalists in this ring. Yeah.
Yeah, out original.
Well, he
I
goes,
can't
he
even
goes,
say
he
it.
goes
I can't even
more
repeat
free to
that.
me than
Yeah.
what Calder v. Bull maybe said.
He's like the original cases might not have gotten it correct.
Yeah. Anyway. But even looking at that case,
Yeah.
we're not applying it right. So, yeah, I'm
Right.
sorry. Go ahead.
And his position is, Justice Thomas's position is, even if you read Calder v. Bull on its face, this is going to be a violation of ex post facto.
The distinction being that Calder v. Bull, it did talk about crimes like this. There were many different opinions at that time because they didn't all write unanimously. But
let's pause.
Justice Thomas, Justice Thomas, just to be
first,
clear,
yeah.
what he was saying was that it's not so much a distinction between criminal and civil laws as it is between public wrongs and private wrongs. So we should consider, instead of all criminal laws or only criminal laws being subject to the ex post facto clause, it's anything that was a public wrong. So anything that the government had the authority to enforce instead of private citizens, that is something that's the actual scope to which the ex post facto clause applies.
What is a public wrong in as short of a way as you can explain versus a private wrong?
I think it's basically anything that the government is the party that prosecutes. I mean, that's the broader point. And so there's huge implications for that if you take that seriously today. because so much of what, that we consider civil enforcement from all of the various agencies, so much of what we consider civil enforcement from both, again, state and federal agencies and agency law that we call civil, and you don't get all of the due process protections for, according to Justice Thomas and Justice Gorsuch, all of those things would be subject to the ex post facto clause.
Can you give me an example of something like that we would consider civil that would fall into this public wrongs category?
There's a big case with the SEC, right? They sued a cryptocurrency company recently, and the SEC is basically bringing an enforcement action saying they weren't complying with the law in the way that they were selling cryptocurrency. And so they were suing for damages and trying to get an injunction and do a bunch of things that are nominally civil, but it was the U.S. government agency suing a private actor for violating a law. We would think of that traditionally as like a public wrong. They're enforcing something on behalf of the public.
Especially because these are crimes. Like a good litmus test is if the government itself created this wrongdoing or labeled this conduct as wrongdoing and targeted it, then what they're saying is that this is a wrong that harms the whole community that we're going to be in charge of enforcing, rather than as opposed to private parties.
Yeah.
And so I know, Nathan, you probably wanted to talk about, well, where does this come from in Calder? I mean, because Calder, of course, allegedly creates the civil criminal distinction, but Justice Thomas is saying maybe that's not right, because we're not, instead of thinking about civil versus criminal, we should be thinking about public versus private. So, I mean, where does that come from in Calder?
Well, so the actual clause in the Constitution itself says there should be the Congress shall pass no bill of it says no bill of attainder or ex post facto clause, and connects those two things together.
Yeah.
And so the bill of attainder is just something that says we're going to give you specifically, Clayton Calvin, a punishment. The legislature says that.
Right.
Whereas an ex post facto clause says we're going to change something that you did in the past where it wasn't a crime. Now it's a crime.
Everybody. That one's not limited to individuals.
Yeah. So it's not just wouldn't be just you.
Yeah.
And both those things, what they're trying to do is keep the legislature, or what they effectively do is they keep the legislature from targeting specific people or specific acts in the past that they just want to exact some sort of punishment on a person. And so does that sort of answer your question?
Well, no, I was asking you, I think,
You may drill down and start and get into Calder, because
we can talk about. Are you want to talk about Calder?
I want to talk about Calder. I don't know what you guys are
why we're
about
postponing the inevitable.
Yes. So let's talk about a case from, what year was it? 1798, I think, or 89?
1789.
1789.
Like day one.
So what happened leading up to 1789, Nathan?
Okay, so Calder v. Bull is an early case in the constitutional history. We have just ratified the Constitution of the United States. In this case, you have the Bull party in Calder v. Bull is a husband and wife, and the husband makes a will that leaves his entire estate to his wife. They have a child, and after they have a child, then the husband dies. And so it's the wife and the child. And what's normally happens in this is that the will goes through a process called probate, where the court decides if the will is valid or not. And the court decides, the court doesn't tell the wife this, but the court decides that the will is not valid because they had a son, and that Bull would have wanted to change his will once they had a son to include the son in the will. And so now we're going to go to what's called intestacy, which is
every bit as miserable as it sounds.
So the intestacy laws of Connecticut in 1789. Please stay tuned.
So yeah, if you want to know all about the intestacy laws of Connecticut, but intestacy is just what happens if someone dies without a will. And so because the court held the will to be invalid, then they just apply what would happen if the will, if he never had made a will. And they said, well, at that time, the wife knew that the estate would go to her son. And so she wasn't too worried about whether or not the will was held up in probate or not.
She just let it happen. She was chill.
Yeah, she's just very chill for a couple years, actually. So during that time, her son dies. So again, she's not that concerned about the probate stuff, probably because she's had 2 crushing losses and all these things. But the court has declared a will invalid, and then Connecticut changes again the law, and they change the intestacy laws so that her son doesn't inherit, so that she doesn't inherit, but her dead husband's cousin is the one who now inherits her estate.
So to be clear,
relatives.
In short order, she is married, they have a happy baby, they're living a good life. Husband dies, she thinks son's going to inherit, so she doesn't hurry her way through the will. And then child dies, and at some point in there, the will that they had is held to be invalid.
Right.
And she doesn't know. Okay.
Yeah.
She's not
So-
even told, because it's like the court actually kind of is
They
reading
kind of
between the lines.
postpone it.
Yeah.
Right.
Well, they decide that it's not valid, but they don't tell her immediately because it's not really her business, is what they say, because she's not inheriting in the will. And so
It doesn't matter to her at all.
It's wild. It's a wild situation. So the cousin is the one that eventually is held.
Whose cousin?
Cousin is Calder, who now enters the party.
The dead husband's
The
the
dead
dead
husband's
husband. Yeah, sorry.
cousin.
So-
The
Okay.
dead husband's cousin
Yeah.
now is inheriting his estate, even though he had a wife and a child who died. But so
To be also, this woman is now remarried.
Yeah,
she
importantly,
does
she
remarry.
is
Yeah,
remarried.
yeah.
Yeah.
I mean,
she does remarry.
Anyway,
But it's
Fun
still
fact.
the
For-
still the
for
facts
those who
are
are
kinda gross.
invested in this story.
Yeah, in the drama,
Yeah.
she does remarry. Yeah.
She-
Yeah, stay tuned for
happy
like
life.
a
Yeah.
Netflix series on this probably.
Cabbage farm. Yeah.
So now the cousin is getting the entire estate of her dead husband, and so she goes to the Connecticut legislature and asks them to grant her some relief from this, and they do, and they we can nerd out on that in a little bit, the method for that, but they basically vacate the probate opinion and send it back to probate court to decide again whether or not we should who should inherit dead husband's estate.
So the legislature intervened in this court process, invalidated that previous court opinion, and sent it back for the court to actually determine the will, which would
got it.
send the property in another direction.
So I have a question. First of all, why does the Connecticut legislature care? Like, how important actually are these people? I don't know if there's an answer to that
so
to that question.
It'd be super illegal if the Congress intervened in this way federally, and that's what we sort of think of with the separation of powers. The separation of powers works a little differently for the states, and we can nerd out on that if we want to. Chance would be the one to nerd out on that part. But it's not. It would be a big problem if Congress did this. It's not a big problem that the Connecticut legislature did this.
Yeah.
All they did is they just vacated the lower court opinion and had them look at the case again. This time, the lower court says, you know what, the wife actually should inherit. That would be the right thing to do. And so now Calder, and I got to say, like, this guy who's like his cousin dies, and he's like
suing
that
wife.
His cousin's dead wife.
Dead cousin's wife.
Dead
Sorry,
cousin's
I keep saying that.
His dead cousin's wife.
His
Suing the
dead
ghost.
cousin's wife. Suing the ghost.
Suing
He's
the
suing
ghost of Abigail.
his dead cousin's wife to get the estate of his cousin. It's very messed up. Maybe
He's
it was a lot of money.
Luckily,
And
their
he
son
just,
died too. Basically, is what he's
Yeah.
saying.
Okay, so what does the court do? The Supreme Court gets this family drama, and what do they do with it?
I'm gonna pitch it to Chance at this point, but it does go up to the Supreme Court I will say that the reason that Calder is suing is saying that you can't change this law after the fact and vacate this lower court's opinion. We already had a final judgment, and I should just have the money. And so because you did this, you're violating the ex post facto clause of the Constitution, Article 1, Section 10. And so you should actually restore the original judgment, and I should take. And so that's the question that goes up to the Supreme Court.
Yeah, they're arguing that it's a retroactive law
Right.
that
Yeah,
targeted
you've
this private
retroactively
conduct.
changed.
Yeah.
Now you'll notice though that the parties at issue here, the government is not a party. It is Calder and Bull, who are both private parties.
And it's not really targeting past conduct so much as it is targeting like a judicial proceeding, which is kind of a distinction.
And I think that's at least worth drawing some attention to, because it's unheard of in our day and age, I think, for the legislature to step in and say, actually, courts, you got this wrong.
Yeah.
Clayton,
yeah,
do you
it
know?
kind of goes in the up until it's in line with the old British tradition. I think up until Tony Blair instituted some reforms in Britain, and only 20 years ago or so, they didn't have a Supreme Court there. They just had the House of Lords was like the final judicial authority.
And the House of Lords was the upper house of Parliament.
Yeah. So this falls in that tradition. I think the state legislatures at the time, some of them, evidently, I'm inferring that Connecticut
clearly,
was one of them.
at least Connecticut,
had the authority to, even though they're legislatures, they had some judicial functions, and the courts didn't have a problem with that. They're like, they were exercising one of their judicial powers. So that seems a little weird to us, but there is a tradition.
Well, I mean, it seems weird because at least by 1795, when you read, say, Van Horn's Lacey versus Dorrance, what the court points out is what makes American constitutions different than British constitutions is this separation of the judiciary from the legislative. The courts can actually strike down legislation as being unconstitutional because they're separate and distinct from the legislative branch. Because in England, like the Bill of Rights is all, unless Parliament deems it in the public interest, there is no standalone judicial independence. And that's one of the more radical things that our Constitution did. I mean, we talk about federalism and other things, but creating an independent judiciary was this unique thing that we were doing, not just at the federal level, but also a lot of state constitutions were creating these independent judiciaries that could strike down laws. And fun fact, just for everyone sitting here, because you all know this, but most of the listeners probably don't. Most of us learned that Marbury versus Madison created judicial review. You'll note that both. Yeah,
that's the wrong take.
You'll note that both Calder versus Bull and Van Horn's Lessee are long before Marbury versus Madison was decided.
What year was Marbury versus Madison?
It's
1809.
Yeah, it's 1800s.
Maybe that's too late.
Yeah,
it's about the.
We have a guest.
We have an attorney off screen who just whispered 1803. So we'll
it's about the
him.
election of 1800, so it can't be much after that.
Yeah.
Okay, so let me slow you down a little bit because I think we're putting the cart before the horse. So in this case, in Calder v. Bull, we have 4 justices and they're all writing.
Yeah.
Why are they doing that?
Because again, until Justice Marshall is on the court and he starts saying that we're going to have an opinion for the court, originally all of the justices would write what were called seriatim opinions. They would just give their thoughts.
I'm just going to opine.
And so you would have multiple opinions in most of these cases where each justice would lay out their reasoning. And so you didn't have usually just an opinion for the court that spoke for the court as a whole. And the, appellate advocates of the time would have to sort of suss out, what.
Yeah, it was on the advocates.
It's not like
the holding. It's a bunch of loquacious men in wigs just sharing their thoughts.
The holding
Were they
was
wearing wigs in America at the time?
Okay, maybe not the wigs.
They might have been.
I don't know.
Chance, do you know if they were wearing wigs at the time?
I don't know exactly when they went out of vogue.
Someday we will have an answer to the question of whether or not they were wearing wigs. Today is not that day. But today is the day to answer the question. In Calder v. Bull, did we have one resounding opinion that came out that everybody seemed to agree with? Or are we leafing through all of these seriatim opinions?
So what we know from all of the seriatim opinions is that they all agreed that when you're talking about the ex post facto clause, that it didn't apply here because you weren't talking about something where the state is suing you, right? This is where the state's bringing an action against you. And this becomes later this idea that it doesn't apply to criminal laws. Now, Justice Thomas, in his opinion in the case we're talking about today, says, well, that's looking at Calder versus Bull wrong.
It's being too reductive and simplistic about it.
Yeah. Now, it's a fun fact that Calder is one of these sort of bad facts make bad law. And, the jerk cousin trying to disinherit the wife of his, dead cousin.
And something that is both not criminal, but also not a public wrong. So it makes it ambiguous.
It's clearly a dispute between two private parties.
Yeah.
Which is, where the facts kind of shake out there.
Right.
So we end up with 4 seriatim opinions, and 2 of them we kind of forget about, and 2 of them are really, really important. But before we get to those 2, why are Gorsuch and Thomas bearing down on Calder v. Bull? Why does it matter, and how does that relate to those 2 seriatim opinions that matter?
Oh man, that's like 2 different questions. So
okay,
the first
let's start with the first question.
So the first question is, why does it matter for the opinion? Is Gorsuch and Thomas, or Thomas and Gorsuch, since Thomas wrote the opinion, they're pointing to this sort of public wrong versus private wrong distinction, which could greatly expand the scope of the ex post facto clause. We talked about that earlier. If that were taken seriously, a lot of these civil enforcement actions would be subject to ex post facto review.
Things like government agencies coming in and suing you for some civil violation would be subject to ex post facto.
So that would be huge. But there's some inside baseball that's going on there that has to do with how we do originalism and how we think about the legislative power. Because there were 2 competing opinions of the 4 opinions in Calder versus Bull that we all get taught in law school. And these are the opinions of Justice Iredell and Justice Chase. And it's about how we think about the legislative power. And Justice Iredell was basically a positive. He makes positivist. He makes the argument that unless the Constitution explicitly restrains the legislative power in some way, that the legislative power is unlimited, just like Parliament. So states can do whatever they want, regulate whatever they want, unless there's an explicit provision of the Bill of Rights that says they can't.
And positivism is just saying that the law is whatever the legislature says it is.
Yeah.
He's like a proto-Scalia kind of.
Yeah, sort of a proto-Scalia.
Worried about unlimited judicial.
Yeah. proto-Justice
Pontification.
Holmes, right?
Yeah.
Whereas Justice Chase writes, and he says, well, no, the legislative power, that had a meaning at the time of ratification, and something that's an act of the legislature isn't necessarily a law. There are certain things that just because the legislature passes them wouldn't be enforceable law. So, for example, he gives a list of things like if it took property from A and gave it to B without compensation, you wouldn't need the takings clause. That would just be theft. That's not within the scope of the legislative power. Or something that made, the wife of A the wife of B. That wouldn't be a law either. That would just be an act of the legislature. And he says that ex post facto laws are the same thing. Something that retroactively punishes something that was legal when it was done is not a law. It doesn't fit within the legislative power. So you don't even need an ex post facto clause.
And Justice Chase is not the first person to suggest this, right? This was actually a debate in the constitutional conventions. Do we need to even write this down?
Right.
Like a lot of things.
And I think in Justice Thomas's concurrence here, he says James Wilson thought that a constitutional prohibition on ex post facto laws. James Wilson was a law scholar at the time, I believe.
Yeah,
Was he in the
he
constitutional
eventually
debates?
ends up on the Supreme Court. Yeah.
Thought that a constitutional prohibition on ex post facto laws would suggest that the convention denied that such laws were already forbidden by natural law to its embarrassment. In other words, if we put this in our constitution, people are going to think we're stupid for not knowing that ex post facto laws aren't laws to begin with.
It's so obvious. We do not need to write it
Yeah,
down.
I want to put an exclamation point on this. Like they were arguing about whether or not they should include an ex post facto clause in the Constitution, but it wasn't about whether or not ex post facto was good. It was about whether or not we even need it, because of course you could never
so
do
obvious.
that.
It's like so many other things too. You just love to see how much in the bloodstream.
Yeah. Locke
this-
was like in their veins.
Yeah, but
exactly.
this has such broad implications when we're talking about things like substantive due process or unenumerated rights. And there's a school of originalism that says that, in fact, if there's not an explicit right or an explicit limitation written out, that like liberty's not broad enough to do it, like that the legislative power is in effect unlimited. But there's another branch of originalism that says the people who ratified the Constitution, the people who ratified state constitutions that vested legislative power, they thought, just like we talk about, the vesting clauses of the federal Constitution or executive power, they thought that there was inherent judicially enforceable limitations on the legislative power without an explicit, enumeration of a right in the Bill of Rights. The legislative power itself has these limitations, one of them being you can't have ex post facto laws. And Justice Chase articulates this. So to have modern Supreme Court justices, modern originalists, like Justice Thomas and Justice Gorsuch, pointing back to Chase's opinion, that's a big deal.
And it's a departure from like the Scalia, Scalia was doing originalism also, but he just excludes that natural law component from originalism.
Like Iredell did. Right?
Like Iredell did.
Yeah.
We've been using this term natural law, and I think it probably bears some definition. What is natural law?
Oh, that's a podcast in and of itself.
Yeah,
We
it
should do a
absolutely
podcast on that,
is.
actually.
But 10,000 foot view, what do we mean when we say natural law?
The law itself, that term has substance, that there's certain pre-existing transcendent things that are required for something to be a law, right?
And where do they come from? Is that also a podcast unto itself?
Yes, it's
Okay.
a podcast unto itself.
Okay, so let's start with John Locke. Where does John Locke say that they come from?
So at least for the founders, there's a pretty good argument, and Justice Thomas has said this before. This came up again last week when we were talking about tariffs, right? That liberty according to the founders is largely liberty according to Locke.
Right.
And so for Justice Thomas, at least, and at least for some of the founders, they're based in social contract theory. And you see this actually in Calder versus Bull. He says there are certain things that are built into the nature of the social contract. So they're borrowing a lot from this sort of Lockean social contract theory. And beyond that, it would be a podcast in itself.
No, let's talk about Aquinas real quick.
Yeah, right.
Right.
It really
Let's
does
go
go back to
even further back.
Aquinas. And Locke, of course, is pulling from Genesis. And
Yeah.
there's this Judeo-Christian sort of framework that they're pulling from. But again, that's like a podcast into itself.
But for purposes of
Which we
this
should do.
conversation, Justice Chase is saying, in Calder versus Bull, Justice Chase is saying there are natural limitations on what a legislature can and can't do. And by legislature, we're talking about state legislatures,
Yes.
because obviously our federal legislature is only what's in the Constitution. But with respect to state legislatures, there are natural limitations. Law is tailored and defined.
Yeah.
Whereas Justice Iredell is saying law is what we make it.
Yep.
And legislatures decide what the law is, so they can decide anything they want.
Right.
Yeah.
Has this proven to be a problem in American history?
Well,
this battle between worldviews.
I mean, this battle ends up being, this is a battle really between sort of the Jeffersonians who wrote the Declaration of Independence that thought that mattered, and this Lockean view is incorporated in our law, and the sort of Calhounian model that says, retcons the Constitutional Convention and says really what we're talking about here is each state had all of the unlimited powers of Parliament. And it's something that comes up over and over again in the early founding era. Without getting too far into it, there was a William Cushing, who George Washington later puts on the Supreme Court. There's a slave petition that gets in front of him when he's on the Massachusetts Supreme Court. And he applies this principle that there's certain limitations on law to actually free the slave. So this is a shot across the bow of the slave power, but it's something that's going on at the American founding.
That was before the Constitution was ratified.
Yeah.
That was like really early.
It was really early. Yeah.
So we have this tension that ultimately kind of leads to the questions that underpinned even the Civil War itself.
Yeah.
Do we see it later on? Do we see it after World War II, for example? Talking about Nuremberg, yeah. Is that kind of the underpinning argument in the Nuremberg trials?
I mean, there's a lot of that in Nuremberg. Like, can you apply the natural law, or is there something that's law that's more transcendent and above, like whatever the legislature chooses to enact? Now, I want to point out that that's different than just creating new rights. No one who does this type of analysis is trying to create new rights. They're just trying to understand what the legislative power would have meant, what that term would have meant at the time that all of these state constitutions had vesting clauses.
So we have two justices who have gone out of their way to say, hey, this is important, to say, hey, Justice Chase's opinion actually means something.
Yeah.
What does that mean for the future of the Supreme Court in the United States? What is it possible that means for the future of the Supreme Court in the United States?
I mean, I think it's going to be interesting. I think it opens the door to make some arguments that maybe people would have thought originalists wouldn't have heard before. And so it'll be interesting going forward in a lot of areas beyond ex post facto laws.
So this is a broader potential outcome.
Yeah. Like within the originalist wing, like, do we look at the original meaning of the Constitution to have these substantive like rights that are not explicitly written down, or do we try to stick more strictly to the text? And this is in the former direction here.
And I think it's like, not to bag on Scalia, because I actually love him, but Scalia would have to excise certain Supreme Court opinions like Calder v. Bull from his view to get to this originalist view that those things were not included. He basically have to say that everybody was wrong in Calder v. Bull, notwithstanding they predated him by over 100 years. And I just want to say, like, we kind of compared Scalia and Holmes, and I just want to, we're not doing that.
They're different from each other in a lot of ways.
Yeah, no hate mail.
But they're
on
also
that.
both different
But they're both
from
positives.
Chase.
Yeah.
Oh, yeah.
But they're all different.
And Thomas.
So we've got just a few minutes left. I think we can probably cover Villarreal v. Texas, which is our other case to talk about today. Villarreal v. Texas was released last week. It was based on a murder trial. It was a direct appeal from a murder trial. And in this murder trial, the defendant took the stand and testified. And after he had started his testimony, but before he had finished his testimony, the court took a 24-hour break. And during that break, in that time frame, the judge instructed his attorney, didn't instruct him, interestingly, instructed his attorney, you can talk to your client, but you cannot talk to him about his ongoing testimony. And this went up on appeal. Is it constitutional for the court to prohibit an attorney from talking to his client about his ongoing testimony in the middle of a murder trial? That was the question that was before the court. And just by way of background, the court seems to take the position, at least the two concurrences in this case, take the position that the right to testify in your own defense is a new right. This is something that wasn't actually in the original meaning of the Sixth Amendment or the Fifth Amendment or the 14th Amendment. This is a new right that was recognized by the court in 1987. So very, very recently. There were some kind of hints at it before, and some states had started making it a statutory right in the 1860s, but really it wasn't recognized by the U.S. Supreme Court until the 1980s. Assuming that those justices are correct, from an originalist perspective, if this was not a right that defendants had at the time of the founding, is this a right that we would say that defendants have currently?
Well, I think that there's a real interesting debate in originalism right now about when you're incorporating a right against the states, for example, what's the date? What's the magic date that you look at to see if this is within the original understanding? So are you looking at the time that the U.S. Constitution was ratified and that Bill of Rights, what those words meant then? Or if you're talking about incorporation against the states, are you looking at, the time that the 14th Amendment was ratified? So if like the right had evolved in jurisprudence up to that point, you would assume that when they incorporated that right through the Privileges or Immunities Clause, did that right carry, the meaning from the 1700s, the late 1700s, or does it carry the meaning that it did in 1865? And so I think that question might be relevant here if you're talking about, at least some states were already recognizing this right in 1865, but whether or not one state is enough to say that that's what the right means. I mean, I think some people would push back on that. But yeah, I mean, there's a really interesting question of like, what date do you look at when you're doing the originalism?
And just for a framework here, 1865, we're talking about the Civil War era, and then immediately following that Reconstruction, which involved the ratification of the 14th Amendment, and which is often referred to as the second founding.
Yeah.
So we have potentially new rights. That's why we care about that date specifically.
And the 14th Amendment itself doesn't refer to the federal government. So theoretically, we might have a situation where something is a right that's protected as with respect to the states, but not protected with respect to the federal government. And that puts us in a really weird place. Are there other rights that might fall in that same category?
I mean, if you take the approach that incorporation doesn't incorporate the original meaning as applied to the states, that it incorporates what people thought that right meant in 1868, whenever the 14th Amendment's ratified, then you could have a situation where the First Amendment means something as to the federal government and means something different as to the states. And that's not the way that we've done incorporation so far. But there's really a raging debate in originalism right now of whether we do it that way and what the effects are. And I don't think we've really figured that out yet.
That's probably something that in later podcasts we will circle, in an appropriate podcast, we will circle back to. But I do have one more question kind of on this, open for the table for discussion. What do we do if we have something that we've kind of accepted for the last at least 20 years? There's some cases prior to that that sort of hinted at it. What do we do with these rights that have developed over time? I think we all know how we all feel about the abortion debate and how that has spun out. But in general, with these rights that we've sort of adopted over time, do we just cut them whole cloth and say, nope, not part of the original meaning, just down the drain? What sort of approach do we take?
I mean, I think Justice Thomas has the best framework.
Okay.
He basically, it's based in something from James Madison called liquidation. And what he says is, look, if there are court cases that are close to or contemporaneous to the ratification, and it's an ambiguous term, so it's unclear what the right answer should have been, that precedent's going to matter. That's the liquidation of the meaning of the Constitution. So maybe he thinks that it was wrongly decided, but if he would have been there, he would have decided it differently. But as long as it's a plausible, likely correct interpretation or possibly correct interpretation, that long-standing precedent matters.
It's basically what he did with the Calder v. Bull, right? He was like, I don't know if this is right, but but I would apply it this way.
But if it's something that's 30 years later or 40 years later, it doesn't get the benefit of the doubt with that liquidation principle. And so you're going to say, okay, well, what is the original meaning? Because remember, the Constitution is the law, not the precedent of the court.
Right.
And so at the end of the day, I think that is the appropriate response, is to say, okay, sometimes that precedent's going to matter, but the further and further you get from ratification, and the less and less tethered it is to an original public meaning, the less respect we're going to give that precedent.
But to be clear, we're not talking about the existence or non-existence of rights. Like in this case, it's sort of like the contour of the right, whether it has this sort of quality to it or not, like whether the Fifth Amendment really requires a Miranda reading, whether the Fourth Amendment really requires the exclusionary rule. Like those are based on rights. And if we didn't have those court prophylactics, then those rights would still exist. It's just they would look a little different.
Yeah.
Absolutely. Well, I think that brings us to the end of today's docket. If you enjoyed our conversation today, please consider leaving us a review and join us next time for more Rightly Decided.